The India Week. We are extremely honored to have the presence of Honorable Justice Tejas Karia. We'll be starting with our session soon, and I would like to invite Mr. Vyapak Desai on the stage to introduce the judge.
Good morning, everyone. I know it's not easy to hang on for so many days with so many events and only talking about arbitration. So we thought today no humans will be involved, it would be only AI talking to AI. So that's the topic. But so today is the fifth and the final day of the India IDR week. And we are very, very delighted to say that the week has really gone very, very successful. We are very grateful to all the participants who attended the ADR week through Bangalore, Mumbai, and now Delhi. There were more than 700 paid registrations, so you can imagine the kind of support that we have got through the ADR week. In India, if you talk about conferences, it's only Saturdays, right? We are doing from Monday to Friday, not on a Saturday. So that's the messaging, that's the difference that we want to make. That this is a serious profession, right? Arbitration is not just a weekend job. So if we want to promote a messaging that arbitration is not a weekend job, then conferences also can't happen on Saturday and Sunday, right? So that's how Monday to Friday, whether it is conference, whether it is arbitration hearings, MCIA and India IDR week, as a pioneer to bring in institutional arbitration in India, here we are to change the culture, change the mindset, and bring best and the next practices so far as international arbitration and domestic arbitration in India is concerned. So with that message, and as India IDR week, as I said, we are very grateful to every one of you, each one of you, to be part of this final day of the 5-day marathon arbitration festival which we do every year. So today we have a guest of honor, Justice Tejas Karia. Now, obviously everyone knows about it, but I would love to talk about him as well. So I would say that everyone knows him and I will not talk about it. I think he has been, in a way, we have started our careers together from Ahmedabad, from Gujarat High Court, and possibly the same year as well, 99, 2000, around that time. And then he came to Delhi, I came to Mumbai, but somehow our paths crossed almost all the time. He has been a supporter of ADR week and MCIA to the extent, we didn't even, had to ask for help or support. He was always there whenever, we thought about him, even as a practitioner. Everyone knows as a practitioner he has done exceedingly well. He was a senior partner with Shardul Merchant Mangaldas, one of the best firms in India, for a very, very long time, and was heading the disputes practice across the offices, and has been a name in the international arbitration and dispute space for more than 2 decades. More importantly, why I would not say we chose him for today's breakfast session. He chose us for the breakfast session because possibly he is also the founder, supporter, member of Chartered Institute of Arbitrators, who is hosting this session as part of India IDR week. The amount of work, guidance, courses that he has handled at the Chartered Institute of Arbitrators and taken the flag across the world that India is the place for the next growth and the training ground for arbitrators in India. So there was absolutely no discussion or debate as to who would be the guest of honor for today's session. So with that introduction and with that very happy moment that we are all together and Justice Karia is with us, may I request Justice Karia to give his keynote speech, and then we will go into the debate after his keynote speech, and I'll introduce the topic as we go on. Thank you.
Thank you, Vyapak, for that personal introduction. I'm so happy to be here amongst you. I thank MCIA and CIArb for inviting me, and it is really my pleasure as the former director of CIArb India to deliver this special address on this very interesting topic of misuse of AI in arbitration and its impact. The importance of this subject today cannot be overstated. The ever-evolving nature of artificial intelligence has made it imperative that the issues around its regulation, impact on innovation and ethical concerns around its use are discussed and debated in a constructive manner. The recent CIArb Guidelines on use of AI in arbitration provides a comprehensive roadmap for all stakeholders in arbitration process regarding how to use AI in arbitration to maximize its benefits whilst mitigating some of the concerns about integrity of the process, procedural fairness and enforceability of the award. It has now become abundantly clear that after penetrating every sector, AI is here to stay. Legal profession is no exception, as AI is already embedded in the legal profession in a manner of improving efficiency and quality, legal research, data analysis, collection of evidence, translation and interpretation, transcription and case analysis, to name a few advantages of artificial intelligence for legal profession. Arbitration, being the process that rests on trust, fairness and finality of awards, faces both immense opportunity and grave risk from the use of AI in arbitration. If AI is used responsibly, it can enhance access, reduce cost and promote efficiency. But if misused, it can imperil very enforceability of the arbitral award, open fresh grounds for challenges to the award and erode confidence in the arbitral process. At a moment when jurisdictions across the world are strengthening their arbitration frameworks, and India too aspires to become a global hub, ensuring clarity on use and the misuse of AI is not merely an academic question, but it is pressing necessity for credibility of arbitration itself. A very less percentage of lawyers believe that generative AI tools will have a transformative impact on the profession. This hesitation is not due to lack of awareness. A key reason is ethical uncertainty surrounding the use of AI. Question about accuracy, accountability, confidentiality, and professional responsibility still remain unanswered. Without proper oversight, relying on AI can be problematic at best and catastrophic at worst. As AI for legal profession continues to be refined and developed each day, it is still crucial to exercise diligence while using it. Arbitration for decades has been the chosen instrument for resolving international disputes. A symbol of party autonomy, a process designed to rise above the rigidities of courts and to provide justice tailored to the needs of the parties. Despite that, arbitration stands face to face with a phenomenon called AI that is revolutionary. AI can listen, read, write, translate, analyze, predict, and also influence. It is already being used to review plethora of documents within no time, to prepare chronologies once consume lot of time, to undertake research and to generate drafts. There is little doubt that AI promises efficiency, but as with every great promise, there is also a peril. Arbitration is not a contest in speed alone. It is at its core the administration of justice through consent. If that justice is compromised by misuse of AI, then efficiency becomes a hollow advantage. The central question is, can misuse of AI in arbitration lead to challenges of an arbitral award? The question is not abstract. It is pressing, real, and imminent. CIArb Guideline is aimed at orienting arbitral process towards informed and judicious decision making while recognizing both the potential utility and inherent limitation of such technologies. The guideline is the first comprehensive instrument to grapple with the dangers and duties that AI introduces into the field of arbitration. The guidelines identifies both benefits and risk of the use of AI in arbitration. It acknowledges that AI can reduce cost, accelerate proceedings, and even provide level playing field for under-resourced parties. Yet, it also warns of confidentiality breaches when sensitive evidence is uploaded into external platforms. It alerts us to the risk of algorithmic bias where systems may favor certain patterns or languages, thereby disadvantaging particular parties. It points to the black box syndrome where outputs are generated without explanation. Above all, it insists that AI must never substitute for the independent judgment of the arbitral tribunal. The black box nature of AI is a system where users have little visibility into how the conclusions are reached. AI can analyze a factual scenario and provide its judgment on the same, but cannot explain how it arrived at the same conclusion. And without understanding how the question was answered in a particular way, the arbitrator or counsel cannot assess the accuracy of the answer. Arbitration is not an automated service. It is exercise of reasoned judgment by impartial human beings entrusted with authority. If arbitrators were to delegate their function to a machine, the very essence of adjudication would collapse. Justice would no longer be seen to be done if it is merely computed. AI should be an aid, not an arbiter. The reason is simple. An administration of justice is not a mechanical process. It involves not only applying the law, but also understanding the context, evaluating nuances, and exercising moral and ethical discretion. AI, for all its computational power, lacks the ability to account for human emotions, social realities, and the complexity of justice beyond legal formalism. The CIArb Guideline unequivocally affirms that recourse to AI by any participant in an arbitral process does not and cannot diminish the responsibility and accountability that the law otherwise imposes upon them. Parties and arbitrators alike are required to exercise due diligence before adopting any AI tool, to weigh its advantages against its inherent risks, and to remain mindful of any legal or regulatory framework that may govern its use. There are specific recommendations that have been articulated in the CIArb Guideline. Firstly, the power of arbitrators regarding use of AI in arbitration. The use of AI falls squarely within the authority of arbitral tribunals to regulate the conduct of proceedings, subject always to the parties' agreement to the contrary and applicable mandatory law. While arbitrators may not be able to regulate the private use of technology by the parties and their counsels, they may nonetheless issue procedural directions concerning the integration of such tools into the process, appoint experts in AI, or require disclosure regarding its use. Secondly, the recognition of party autonomy for use of AI. CIArb Guideline affirms that the party autonomy lies at the heart of the arbitral process. Parties retain the right to determine whether and in what manner AI shall be employed in their proceedings and may even stipulate the parameters of such use by mutual agreement. Thirdly, the resolution of dispute arising for artificial intelligence. The arbitrators are entrusted with the powers to rule upon the questions concerning the admissibility of evidence generated through AI and they address manifold challenges that may arise therefrom. Finally, the disclosure. Transparency is underscored as an essential safeguard of arbitral integrity and enforceability. Parties may be directed to disclose their reliance on AI tools whenever such use might affect the evidentiary record, influence the outcome, or amount to a delegation of duties that properly belong to the arbitrators or the parties themselves. Regarding the use of artificial intelligence by arbitrators, the discretion to utilize such tools to assist in processing voluminous material or enhancing efficiency is retained by the arbitrator. Yet, the cardinal principle remains that the decision making cannot be left to the technology. Transparency in this context is paramount. The arbitrators are encouraged to consult with the parties prior to deploying any AI tool, affording them an opportunity to raise the objections. In instances where parties are not in agreement, the arbitrators are expected to refrain from employing the specified tool. In a three-member tribunal, the arbitrators are advised to consult with one another regarding the appropriateness of AI within the mandate of their collective adjudicatory responsibility. The Arbitration and Conciliation Act 1996, as we all know, sets strict boundaries for when the award may be set aside by the court. Section 34 provides that an award may be annulled if a party was not given proper notice or was unable to present its case if the procedure was not in accordance with the agreement of the parties, if the award is in conflict with the public policy of India, and or in the domestic arbitration if it suffers from patent illegality. These are narrow, exceptional grounds. Yet it is through these narrow channels that the issue of AI misuse will have to be considered. Take an example of a ground of being unable to present one's case. The tribunal uses AI tool to summarize a vast evidentiary record. If the tribunal relies on a summary without reviewing the underlying evidence and omits key exhibits favorable to one side, and the award is rendered against that side, that losing party may argue that it was effectively denied an opportunity to present its case as its evidence was never truly considered. Indian courts have consistently found that the awards where the evidence available on record was not considered or relied upon by the tribunal can be set aside. The fact that deprivation arose from a machine's omission does not absolve the arbitrator of their duty to give equal opportunity to the parties to present their respective cases. Another ground for challenge of award could be that the process followed by the arbitrator was not in accordance with the agreement of the parties. If the tribunal uses AI to draft the award, it would be a direct violation of party autonomy, which is an essence of arbitration. Indian courts have also held that violation of agreed procedure can nullify the award. The ground of patent illegality, though cautiously interpreted by the Supreme Court, allows intervention when an error goes to the root of the award. If an award refers to AI-generated legal research that cites judgment which do not exist, it is an illegality apparent on the face of the award, and patent illegality would, in such a case, be a fitting ground for setting aside the arbitral award. The courts in India have carefully set out contours of public policy. Fraud, corruption, fundamental unfairness are recognized as contrary to public policy. If by misuse of AI, confidential data is recklessly exposed, or if an award is rendered in a manner that shocks the conscience of the court, the award may be set aside or refused enforcement. One may ask, how receptive will Indian courts be to the arguments that the award shall be set aside on the basis of use of AI while drafting the award or adjudicating the claim? Where misuse of AI causes demonstrable prejudice to the parties' rights, Indian courts may not hesitate to set aside the award. Arbitrators should incorporate express provisions in their first procedural order which is well known as PO1, about use of AI. What tools may be used, for what purpose, and with what safeguard should be clearly outlined in PO1 itself. Parties should be free to object to or to propose limits. The arbitrators should record their awards where AI is used, in what capacity and how outputs were verified. Misuse of AI can indeed be a ground to challenge an arbitral award in India, but only where it strikes at the root of fairness, autonomy, or illegality. The law will not annul the award for trivial errors, but where the misuse of AI causes real prejudice, the courts will be compelled to intervene. CIArb Guidelines of 2025 is not a binding law, but it is a persuasive authority and a reflection of emerging global standards. I conclude by saying we must ask of AI not what it could do, but what it should do. We must remember that efficiency is a means, not an end. The end is justice. And justice requires that the arbitration remains human in its essence when it is embracing the technology. If we forget this, we may gain speed but lose legitimacy. If we remember it, we may find that technology, far from being a threat, become a trusted ally. The choice lies with us, not with the machines. I am sure that this session will provide some useful insight about use and misuse of AI in arbitration. I once again thank MCIA, CIArb, and all my friends for giving me this opportunity for sharing my thoughts with you. Thank you.
Justice Karia for giving such a wonderful keynote, laying down the broad spectrum of things that we are looking at. I think he has to possibly leave. He's also part of the committee at the Delhi arbitration weekend, so I'm sure he has many other commitments. But thank you, Justice Karia, for everything that he has done for the India ADA week. So with that, thanking speech to the Justice Karia, can we start our session on the misuse of AI? May I invite our speakers, Chung, Ajit, Kumar, Mishra, and Bharat Singh for the session. Of today, we have carefully crafted. It's not use of AI, but misuse of AI. And Nusrat, Andrela, myself, we were discussing what topic we should, look at. So, Chartered Institute of Arbitrators, which under whose auspices this session has been conducted, came up with the guidelines on the use of AI in arbitration in 2025. It's a very instructive guidelines. It gives a very clear, pointers for do's and don'ts for both the parties, counsels, and the arbitrator, particularly to say what should be done and not done. So one is the guidelines itself, but I think the point that we wanted to focus on is misuse of AI in arbitration. Can it be a ground for challenge to an arbitral award? Now, one may think that this is a theoretical subject or something which may happen in future, or this is academic in nature, or this is just to create some discussion and therefore the topic is around. That's not the case. We already have a case in the US courts where an award is challenged specifically on a ground that the arbitrator misused the AI in writing the award. And if I may just read 3 or 4 lines on the points on which the challenge application is filed in the courts in the US. Claimants conclude that arbitrator during the hearing told a story about how he has been assigned to write a short article on an aviation club he was part of, and that he had used ChatGPT to write it to save time. Now this was during the conversations at the time of the hearing. The arbitrator noted for the parties that he was leaving for a trip on a holiday soon and wanted to get the case done before that. The award allegedly contains telltale signs of AI generation and purportedly cites facts that are both untrue and presented at trial or present in the record without any relevant citations. The claimant counsel's law clerk asked ChatGPT whether it believed a certain paragraph was written by humans or AI, and ChatGPT stated the paragraph's awkward phrasing, redundancy, incoherence, and overgeneralization suggest that the passage was generated by AI rather than written by a human. Now, these are specific grounds on which the award has been challenged, and you know what is the ground for challenge? The arbitrator has exceeded its scope beyond the agreement between the parties. Parties never agreed that the arbitrator should use AI. So look at it, right? We are talking in very real time where the misuse of AI can actually be a ground for challenge. So with that introduction and that importance to this topic, may I just introduce the panel here. Chung, she is a senior partner with Norton Singapore. She has been part of the international arbitration and disputes practice for many decades now and a well-known name in the international markets. Bharat Singh, he's a general counsel with Jacobs. It's a design and infrastructure company, multinational company based out of US, and he's been part of the India group for a very long time. He was also earlier a practicing advocate with one of the leading law firms, Amarchand, at that point in time. And Ajit Kumar Mishra, of course, again, everyone knows Ajit. He's been part of many organizations, recently joined Irkon International. Before that, he was with the dedicated freight corridor and been part of many disputes, contract, general counsel. He advises the company and the board at the highest level. So thank you everyone for spending some time with us on this topic. So may I straight away go to KP on what are we seeing internationally? Is Singapore or other jurisdictions like the US, China, Hong Kong, Asia coming up with do's and don'ts, instructions, guidelines? How is AI creeping into the international arbitration space?
Thanks, Vyapak, and thank you to FCI and CIArb for having me here to speak. In terms of the international scene for the use of generative AI, at least 6 different jurisdictions have come up with some sort of guidelines, and that includes your own Kerala High Court here in India. The Singapore courts, Hong Kong, United Kingdom, Australia, Canada, and the US have looked at generative AI and have said, look, we need to try and govern the use of this generative AI in the courts and set out some sort of guidelines and parameters to deal with how it's to be used and to what extent it can be used and what happens if you use it. I think what is notable about the Singapore courts guidelines is that it runs to only 6 pages, which is relatively short for a list of guidelines from the Singapore courts. And it essentially makes 2 points. The first is that it presumes that you can use AI in your submissions and in documents that you submit to the court. But the second important presumption in the guideline is what I call the show and tell presumption, meaning that if you're asked whether you have used AI, then you need to be prepared to show which parts of your submission, your affidavit, or your evidence contains generative AI content. And you have to justify to the court why it was used, and also if it happens to breach your duties, then you do have some answering to do in the courts. So that at the moment is the scene in Singapore. We haven't gone into the detail of the CIArb guidelines, but I think we'll come to that in a short while.
Yeah. No, I think again, use of ChatGPT and AI is no more just a US or a Singapore or a Silicon Valley, domain. Our own Delhi High Court, our own Honorable Justice Pratibha Singh was, faced with a case where the plaintiff in the case submitted that they had used ChatGPT to show that there was reputation of, it was a case on red soled spiked shoes. So basically it was a case of whether there was an infringement on their design, and they had used ChatGPT, and ChatGPT had answered that yes, they have a very good reputation in India. So that was part of the submissions before Justice Pratibha Singh, and Justice Pratibha Singh opined that the response of the large language model based on chatbots such as ChatGPT depends upon numerous factors which included the nature and structure of query put to by the user, the training data, etc. The court further stated that accuracy and reliability of AI generated data was still a grey area. There were possibility of incorrect responses, fictional case laws, and imaginative data being generated. The court stated undoubtedly at the present stage of technological development, AI could not substitute either human intelligence or the human element in the adjudicatory process. So this is not US, now this is Justice Pratibha Singh in a reported order which you can find in the... So if I come to Bharat on this, and obviously you being part of several international contracting and disputes as it arrives under those contracts, and you have also looked at the CIArb guidelines on AI and arbitration. How do you see all of this panning out? How do you see the AI use in your advice both to your company, to your counsels, to the arbitrator or to the counterpart? Because you never know what is coming out of AI in your day-to-day operations.
So thanks for that, Vyapak. So I mean, this would really be an in-house perspective. So I work in a solutions and technology company. So that in part is a reflection of my views as well, that there's been a march of technology within the corporate world. So I cannot say that the litigation or legal departments are averse to such change. So I think, and what I've seen happen really is, and probably there was a silver lining in that the COVID pandemic was that the legal profession adopted a lot of technology. So there's been online dispute resolution guidelines. There have been various other use of technology in the dispute resolution process. And the only change I've seen in the last couple of years is that technology was used more in the extractive sense, and now we're getting to an age of generative AI. So we have large learning models that are coming in, and that's where I probably see the risk that it served as a great tool when you talk about extractive AI. When I started my practice, you had tools like Manupatra, ICC Online, and now it has reached another stage with Westlaw Edge and LexisNexis and relativity. Can add so much efficiency in our work processes. I mean, I see the benefit clearly in terms of reduction of costs in an arbitration, choice of arbitrator to check their impartiality, just efficiency in caseload management and documentation review. So the benefits are huge, but the pitfalls are there, as well. So you've cited a few examples. I think I read somewhere that since ChatGPT came to existence in 2022, there have been, I think, 122 or 123 misuse cases, perhaps just in America alone, and I think there's a very famous case in the Southern District of New York, Matt versus Vyapak. So I mean, the lessons there were that it's going to be a supplement, not a substitute. And I think lawyers and arbitrators need to have that supervisory responsibility. And as far as arbitrators are concerned, you really cannot see that decision making, which really vests in them. So we had Justice Karia talk about the trust that is placed in the arbitration process, the autonomy, and we really need to ensure the fairness, the independence, the confidentiality of the arbitration process, keeping the benefits of innovation in mind. So I think CIArb guidelines are a step in the right direction. I think they recognize the use that it's going to play, the transformative use that these use of AI will play in arbitration in terms of all the efficiencies that I talked about. But then they sort of laid out the roadmap as well. We talked about whether an arbitrator can use AI. Yes, it can use to add efficiencies for administrative purposes, but it cannot sort of cede the core function of decision making and analysis to an AI tool. And of course, there's disclosure requirements both for the arbitrator and the parties, and it provides clear guidelines. In fact, I was happy to note that there are templates for in-house counsel like us to use in terms of permissive uses, permissive tools for AI. So it reflects upon the party autonomy, that we actually can decide how AI is going to govern our dispute resolution process. The only other thing, which is very important from my perspective, is that we have to give, there's a certain amount of sanctity that must attach to confidentiality. Disputes before arbitration are not only complex, but businesses are bringing technological advancements, patented right, business plans before an arbitration. So I think the tools that we use will be very important. I think Perplexity, ChatGPT, these are open source models, so we will, as a legal profession, we'll have to, we understand the risks, but I also know that there are a lot of tools in the market that keep legal sensitivities in mind, and we've used some in our arbitrations as well. So we'll have to tread with caution, but I would like to sign off with a note of optimism, simply because I think as lawyers, we're a little averse to change. And sitting where I do in a business, I feel that we'll be left behind. So we should adopt it cautiously, but we should definitely adopt it.
So Bharat said it is not something can be part of decision making, and we as lawyers are cautious. But I tell you, I just gave you one example of Justice Pratibha Singh. Can I give you another example where Punjab and Haryana High Court, in a bail on an assault with cruelty case, again in a reported judgment, the court has confirmed that bench asked the AI tool, what is the jurisprudence on bail when the assailant's assault was with cruelty? To which ChatGPT responded that jurisprudence on bail for cases where assailants have assaulted with cruelty will depend upon specific circumstances. However, in general, if the assailants have been charged with a violent crime that involves cruelty such as murder or torture, they may be considered as a danger to community and a flight risk. In such cases, judge may be less inclined to grant bail or may set the bail amount very high. And this is again a reported order from Punjab and Haryana High Court, while judge said that this was just a guidance and it did not depend, or his judgment was not dependent on what ChatGPT said. But it has gone much beyond arbitration, it has gone much beyond decision making. And I don't think we can even say that we are far away or we don't use it. Delhi High Court, Punjab, Haryana High Court, we may say, okay, these are very important and high courts with a lot of substance, or they understand what is happening in ChatGPT. Guwahati High Court, right? One can say, oh, they are still catching up. Guwahati High Court, in a civil case of termination of voluntary defense personnel, asked the respondents and the petitioners to give more information on the case. Both the lawyers were not able to give the information. the Guwahati High Court again confirmed in an order which is again reported, which said that we then asked ChatGPT because we were not getting information from the lawyers, and ChatGPT gave them a notification in reference to voluntary defense personnel who were inducted in Guwahati a few years back, whether they should be terminated or can be terminated, and they used ChatGPT and Google for doing their search. So we have gone from arbitration to criminal matters to civil matters to high courts, Delhi, Punjab, Haryana, Guwahati, and we lawyers here are sitting and thinking whether we should use or not use. So I think the world has gone much beyond. It's only a question of how we are able to control or use it in a more efficient manner rather than whether to use or misuse. So with that, Mr. Mishra, you obviously are part of several of the large government organizations. You have done contracting worth billions, you have done arbitrations in India, across the world. Some of your cases are very well known. So what is your experience? And more importantly, when you go to a law firm, when you go to a counsel, when you go to an arbitrator, sitting in your own office, what are the do's and don'ts you think? Do you put it in writing? You tell them, don't give me something which AI has generated because that's not why I have come to you? Or do you use it but make sure you are not charging for 200 hours for which AI has done it in 10 minutes? I don't know. How do you cope up with this whole use and misuse of AI?
Thank you, Vyapak. And that's really a very interesting question and rather basic one, because that should be the first starting point when we are going to engage in lawyer or counsel. Let me start with the conclusion first, is that I am not worried about use of AI. I am worried about misuse of AI, and that is the whole session is about. When I approach a lawyer, there are different tiers of lawyers. We have tier 1 law firms, very brilliant lawyers, and then down below we have associates. All those categories are there. But the chat GPT, I can't brand it like he's an excellent lawyer like Vyapak, or he's a novice just graduating from a law college. There's no such classification. So when I approach law firm, and interestingly, I pose this question to ChatGPT itself, and the response is interesting. I would like to throw on you. What ChatGPT says that when you engage a counsel, there are certain do's, and it says 5 do's. First one is the encourage responsible AI adoption. What Vyapak warned about the generalization. Next one is use AI to improve productivity, not replace judgment. Again, a kind of generalization which we expect. Third one is adopt AI-powered due diligence and risk mapping. It's a very fantastic words, but the meaning down below in practicality, I'm still to fathom out. Next one is ensure secure AI platform. That's one of the very important thing, and one should be very careful that wherever you are giving your client data to any lawyer, there is obviously the client attorney privilege, and then you believe that your data, information, case details are secure with your counsel, and the same is expected if you are hosting all those details on the on any of the this cloud for use of AI. So that's one of the very important aspect one must care. And then it says that ask for an AI use protocol. Again, we have been talking about the CIArb protocol and the protocols used by many other institutions. So this is the limitations, or you can say the fragmentation of if you are going to ask AI into this. It is a paid version of AI. Probably if you go into the higher and higher and better versions of AI apps like relatively Harvey, probably your quality of response will further improve. But what matters to me most is I have faith on intelligence of say a lawyer like Vyapak, but I still don't have faith on what AI will produce me. So I will be very, very careful when approaching to appoint a lawyer, and I humbly request them, please, I have come here to engage you, not AI, because that I can do, I can subscribe sitting in my office, I don't need to come to you. But I'm also conscious that in today's world, if some tool is available to you, then you cannot refrain from it. I mean, you must use it to increase your efficiency. And so to that extent, I am still acceptable to allow use of AI by my counsel. And what I request him is to look the general boilerplating or framework creation of, say, if you are preparing a statement of defense for me, you get it done through AI, but wherever important critical decisions are coming, you should apply your mind. Don't rely on AI. So that's the basic thing, and I think more will come later.
Yes. So, Katie, coming back to you, I think what are the areas internationally now it's almost accepted that these things like research tools, right? We know everybody does Westlaw or SEC online. It's all accepted. People, even in courts, will give SEC online judgments, right? It's accepted. You don't have to take a print from AIR manual or something like that. So, what are those accepted norms internationally that it's fine? Everybody knows this is AI and not human.
Yeah, thanks, Vyapak. It's an interesting question because what you're asking is developments that have taken place in the last year or two alone. You know, post-COVID and the adoption of AI has been just transformative. So international law firms have obtained licenses to use Harvey, for example, to incorporate that into their own systems as a closed-loop large language model. Copilot is now used in my firm. We have a license for Harvey. And this is all meant to improve efficiency and provide a more value proposition to clients, like Mishra and Bharat, as to how we use our associates in giving advice or acting in transactions. So it's become accepted that a law firm can use generative AI for their work, and the question really is how you can harness the capability of AI is by inputting a prompt or prompts that are accurate enough to get the result that you want. So for example, if you wanted to generate chronology of events out of 100 documents, can the generative AI in your closed loop large language model deal with that without error? And that, I think, I have yet to see the result of that kind of product, primarily because I don't have a license to Harvey for some reason, but my associates do. So it's something that, I think with time we can see that generative AI is just going to be part of the work. And I think clients have come to us with fee proposals, requests for fee proposals, and say, how do you intend to use AI in your work? And that really is a question going to efficiency. And there's an expectation that if the AI can do it, then you're not going to pay for your associate to get it done. So compiling documents or putting together chronology, that kind of thing is, I think, half of the course in Singapore. I heard from a local law firm partner that their Harvey closed-loop system is so good that they don't need a first to third year associate anymore. They can, they don't need that junior level of lawyers to work on more menial stuff. So I think that's transforming the legal landscape in Singapore, and it's something that I think is welcomed.
Sure. So Bharat, are there you guys are doing training internally for your teams? You have created your compliance modules for your lawyers, they have to sign that the KYC, or they have to sign no bribery policy, or they have to sign certain vendor or onboarding them as lawyer policies. Has AI crept in either for internal training or external lawyers onboarding? What kind of things that you are seeing? And of course, you can throw a little more light on the guidelines as well, but your take on a couple of those points.
So I think what has happened very recently is that from an in-house counsel perspective, there's a lot of vendors are coming to us to actually adopt their AI tools. So I think we are right now at only sort of exploratory journey as to what tools we can embed. The advantage or disadvantage for us is that we are, as a corporation, we are on the Microsoft suite of, your 365. So I think an adjunct to that is Copilot. So, then of course there's Copilot for legal. So we are exploring these tools, and I think there are a lot of tools that can actually help in, contract review. Compliance is a big issue. I mean, just last week we were looking at, as an international company now, there's a big push towards things like compliance with modern slavery. You have to have your vendors and suppliers have to comply with modern slavery requirements in terms of due diligence and things like that. And that's like, we have 60,000 vendors. So I think no matter legal department or compliance department will actually be able to vet so many vendors to provide that assurance to business. There may be other requirements as well. I mean, FCPA, bribery and corruption, UK Bribery Act. So there are these vast amount of compliance requirements that have come on companies, and I think AI tools will actually play an important tool, important help in actually with these processes. But again, it cannot at the moment completely remove human oversight, but yes, it is very helpful.
Sure. Mr. Mishra, I think the topic, can it be ground for challenge to an arbitral award? I think we already have seen how technology has crept in and grounds for challenge have gone all the way to copy-paste awards. And it involves India and Singapore in some sense. But now AI, can it be a ground? So while you are doing so much of contracting, arbitrations, disputes, millions and billions of dollars are at stake, how big is this topic in the minds? I know there are many more important issues that you deal with on an everyday basis, but how is AI being part of the whole metrics on decision making, on running your department, or running your legal function? How is AI working on this?
Let me start with my basic concerns once again. My concern is that about the arbitral award is that who is writing my award? And one instance you mentioned, the another one which had been traditionally in practice, may not be in public domain, but most of us had understood, is the concept of fourth arbitrator, that is the tribunal secretaries writing the awards. So this has been in practice. Now another dimension has come up. Now AI has come and the people feel it very comfortable that let's put things to the AI and let him decide, and then I'll just take a printout and sign the award. So per se, what AI is doing, the kind of mischief, or where the arbitrator, you can say that, where the arbitrator is not fully involved into the case, that was the case earlier also. So this is not my basic concern. What with the use of AI now is that tribunal secretary was still also a human being. He was also have gone into the cases and he was having certain set of experience, and probably his decision was even human decision. But Justice Karia said that all the justice and you can say equity or whatever, the human angle was still involved there. With AI, it is completely missing. So it can run into a bias which you don't know. You can understand a bias of a human arbitrator that he has worked into, say, this kind of law firm, or he has worked into this set of previous judgment he has given. So you can understand his bias, his either anchor bias or confirmation bias, but that is understandable. With AI, this kind of bias is completely not clear. So I don't know what kind of decision I am going to get with the use of AI. So you have given so many examples from different jurisdictions in India also, that is going to be very much in practice nowadays. My concern as a user, and when I am awaiting an award from learned arbitrator, my concern is let him apply his own mind so that he gets connected with our case, the issues involved into it, rather than mechanically dealing with it. Otherwise, we both sides are very competent, very knowledgeable. If this kind of machine judgment is required, probably then we don't need the human arbitrators who are sitting this. And about the final point about the grounds of challenge, I think section 34, if I focus on India's case, this issue can be indirectly brought into that the procedural fairness. And because the judge or arbitrator has not used the process of judgment in fairness and equality, number one. Second one is the patent illegality ground you can brought in, is that probably the arbitrator adopted a process which was not acceptable to the party, neither disclosed to the party. It wasn't reasoned based on what the parties had submitted. So all these two narrow grounds we can pick procedural fairness.
So you don't think we are close to a situation where rather than the human element and the uncertainties, people would choose AI to do decisions? Are we coming to a situation where people would believe more on machine and AI rather than humans?
Yes, see, lot of decision making has been made automated. I mean, in any business you go and say that you will find many decisions have been automated. No interface of human at anywhere. Right from your DC Yatra, when you just show your face and you are entered into the airport. So all those kind of things are happening. So I mean, if we as an arbitrator or the community decision-making community, if we don't behave like humans, probably the day will come when both parties will throw their or submit their cases, and some printout will come. This is the decision.
I'm using AI every day. Uber, I say sorry, the driver was bad, and he pays me my money back, right? Yeah. So AI is giving a decision straight away every day on my travel. So it may not be as complex as possibly the arbitrations we do, but decision making on Uber is the classic example that anybody can make a decision, a machine can make a decision. So before going back to our speakers, I know it's a breakfast session and we should be mindful that you all are here, but any thoughts, comments, questions from the audience? I would like to rather take it now before we come to the close. There is one question at the back, and then Naresh. Yeah, if you are louder enough, it's not a big room, so please go ahead.
I thank you very much to the panel. I'm really enjoying the session. My name is Professor Kenneth Wade from CIArb India Branch. I'm just wondering the extent that provisions that are quite common when it comes to irregular awards can be applied to AI. I'm thinking the question of affording the parties a reasonable opportunity. That's normally a ground in which an award can be challenged. And I just wonder to the extent that that could be interpreted in the context of the discussion today, because the human element is actually stepped out and it's just a machine doing the work. Thank you very much.
So claimant in the US said arbitrator went beyond its power under the agreement, but Kitty, you have any thoughts on the question?
So interestingly enough, the Singapore Court of Appeal's decision in DJO and DJP, I think Vyapak, you mentioned the copy and paste case. The Chief Justice Sundaraj Menon does go into some detail to discuss the fair hearing rule. Albeit in the context of the copy and paste situation, I think the principles that are set out in that case can be applied to how generative AI is to be used or not to be used in the decision making of the tribunal. So if you take a step back and you look at generative AI and what it actually is, it's actually a large language model that is trained on vast amounts of text, right? And it uses probabilistic models to predict and generate text responses based on output in a given context. The LLM doesn't understand the words or used or generated, and so it doesn't apply reasoning or thinking. It just produces likely sequences of words based on statistical patterns. And so if you think about that and you apply it to making a judgment in a case, you would find that it actually is not able to make the decision for the arbitrator because you're putting together data, it comes out with words, but it doesn't mean that it's applying any rational thinking to the documents or to the submissions of the parties. And so if you think about the fair hearing rule of what a tribunal must adhere to and the need for the integrity of the process to be respected because of the finality of arbitration. What comes to mind when you look at generative AI is that the tribunal cannot use Gen AI mindlessly, right? They must apply his or her mind to the issues and arguments that are live in a dispute and submissions and evidence adduced by the parties. You can't just stick it into, Gen AI, Harvey or Copilot and expect to come out with a result. I know there's a time limit on rendering awards, but you need to actually type it on your own. And the second is you cannot decide the case on the basis that it wasn't submitted or contemplated by the parties. So you can't just deal with it without applying your mind to how the data is to be dealt with, how the legal submissions is to be construed, and the interpretation given to the law that is to be applied. So it's not an unthinking adoption of a party's position. And so in essence, in order for generative AI to be used properly and without misusing it, resulting in a challenge of an award, the arbitrator has to, I think, set out clearly to the parties that I'm going to use generative AI in X, Y, and Z steps in drafting the award. And these are the parts of the award that will use AI, but there are these other parts that will not use AI. So procedural history and facts and parties, arbitration clause, all that.
And not on the analysis.
Yeah,
sure.
Not on the analysis.
Naresh, you had raised your hand, but there is one more question here.
Thank you so much. My name is Naresh Thakkar. I am a counsel in the Bombay High Court. I have just one comment, and I think, Kitty, what you mentioned is what I was about to say, but maybe put it in different words. You are right. I think as an arbitrator, when one sits down to write an award, there are emotions, motive, what you hear, what you think. A lot of self-awareness as a human. When you're writing an award, and there is no self-awareness in an AI because it's a tool. You're right. There's a lot of data, a lot of coherent data which has been fed in, and maybe what you get is a lot of coherent data set as an output. When you have that input, which is a coherent input, you get a coherent output. You have an incoherent input, you get a bad output. So that's how it works. As a human, you're working in a very different way because I believe that as a sentient being, you are self-aware. Whether you are an arbitrator or otherwise, whatever you do with a certain set of emotions. Those emotions are totally missing, and it may very well be that the future of AI is that it will become self-aware at some point in time. Now, at what point in time will it become self-aware is the question that I don't believe anyone has an answer to. I think Bharat, when you mentioned that, what is the time? Today is not the time to replace humans. I had just at that point turned around to ask Mishra, when really is the time? When will any one of us know when really is the time for, the machines to replace us?
Machines will tell us.
So machines will possibly.
These days when you get into the computer, the first question is, please confirm you are not a robot. Now like machine is asking me that you are not a robot, but that's where we are. But maybe one more last question. We obviously need to end at 10, but yeah, we'll take a couple of more.
Hi, Robert from Partner Has Law Firm. So we've come from Dubai, myself and my colleague, and we work a lot in arbitration internationally and domestically. My question is it not correct that it should be mapped out during the procedural order in the preliminary hearing, the use of AI? And my view on it is that in circumstances, the only onus on the arbitrator is to raise that to the parties, insofar as saying, parties, use of AI, please provide your comments.
Sure.
Yeah?
So I think CIArb
Guidelines include this procedural order. You can have one short procedural order, or you can have the long form of agreement between the parties while you are stating.
So that's exactly the topic and the reason why we wanted to emphasize. Chartered Institute of Arbitrators guidelines to address the point as to how to integrate this as part of the arbitrators' discussions at the early stage.
Whilst it does recognize party autonomy to choose the process of use of AI, it also recognizes that where it doesn't, it lays out that it is within the arbitrator's power to set out the procedure. It should be done at the first case management hearing. And in fact, the order, there's a detailed order which is very prescriptive, which actually parties have to disclose the AI tools which they intend to use. The other party has a right to object, and then the arbitrator makes an order based upon it. So I think the CIArb guidelines really do set out the detailed procedure.
That's great, thank you.
You have something, and maybe then we can close the session.
Just
Please.
Just a quick comment. Just as CIArb has come up with the guidelines, the other arbitral institutes also will come up with certain rules whereby the use case of the AI in the arbitrations could be defined. That the arbitrator could use these are the areas where the arbitrator can use or the parties could use, as mentioned that in the procedural order or in some other form it could be included. I can't comment about ad hoc arbitrations because it's in India it's covered by Arbitration Act, and the Arbitration Act is silent about it.
Sure.
But it will be
So I think people are taking steps in this direction. Silicon Valley Arbitration Center has already given guidelines 2 years back as to what parts of the arbitration, if you are doing institutional arbitration, should be governed, or what are the do's and don'ts, basically what you are saying.
The guidelines will again not be enforceable as such.
No guidelines are enforceable, but it's all about correct. It's same thing with Chartered Institute of Arbitrators guidelines. They are all, but question is, the AI is treated like a unknown territory, right? You don't know when you say use AI, you don't use AI. Nobody understands what does that mean and what extent that can be used or misused and can creeping into things which were not originally thought of. So we are coming to the close. I know, like Madhupeshwar and Niti straight away barged in. That's it. But
also to add what you said about the courts, Indian courts about talking about the use of AI. So there was Madras High Court judgment where they've come up with the rules where how much AI or to what extent the AI can be used by lower courts or the courts in giving the judgment.
yeah, so I think KT also mentioned Kerala High Court guidelines, and of course everybody is trying to put that thoughts in. But I think this topic obviously deserves a day and not one session. But we thought it might be a good start, at least as Chartered Institute of Arbitrators have come up with these guidelines to talk about it. We also have our directors, INBA and Nusrat, who are part of the directors at the Chartered Institute of Arbitrators, and Neeti, who wears several heads. I don't know how many heads she has, but she is also a director at the Chartered Institute of Arbitrators, and we come up with a lot of training courses. You can see them available on the Chartered Institute of Arbitrators website. There are paths to become proficients on arbitration and arbitrator roles, and these guidelines will, I'm sure, creeping into many courses that CIArb would be running over a period of time. So please keep a tab on the CIArb family and CIArb world to get more information and more discussions on this. Session cannot end without thanking the MCIA team, Diana, Duhita, Anushka, Andrila from the CIArb team. I don't know, she's CIArb and MCIA team as well. But this session could not have been possible without them. So thank you, Diana, Duhita, Anushka, Andrila. Thank you all the audience. Friday morning, 8:30, not an easy time to be part of a session like this, but hopefully the humans made a difference to your morning, and I don't know when AI would decide which session to attend and not attend for you. But good, today you made your own decision to attend this session, and can we have a very big round of applause for the speakers, Bharat, and Ajit. They are in the midst of dealing with AI, and hopefully they would be able to come over the misuse or the threat of AI in the human legal world. At least we don't know what other worlds will be using AI. And thank you all the sponsors of the India Idea Week and supporting the CIArb session today. And again, thank you everyone.